Hello everyone. So in our previous video we discussed how this constitution came into being and what really happened in earlier days, how the king they legitimized their authority through divine theory of kingship, and then how French Revolution happened and a new political paradigm came into being, that is called popular sovereignty, and the concept of social contract became important. And then we discussed the preamble of India, and now here we are going to discuss one very important topic, that is the fundamental rights. So why fundamental rights are important, or why at all rights are important? So as we discussed earlier, that despotic rulers or the kings and queens, they have this tendency to misuse their power. So as Winston Churchill said, that power corrupts and absolute power corrupts absolutely, and that is why there were lots of corruption. Okay, so the first instance of some civil right comes from Magna Carta, and that is why this word or this phrase is very important. Magna Carta is a royal charter of rights agreed by King John of England on 15th June 1215, drafted to make peace between the unpopular king, he was despot, he was unpopular, and group of rebel barons. It promised the protection of church rights, protection of the for the barons from illegal imprisonment, access to swift justice, and limitation of feudal payments to the crown. So basically what we are seeing, we are seeing that the ruler, he became a tyrant, okay, and to safeguard themselves from the tyranny of the ruler, they demanded something called rights, and that was Magna Carta. So it was the beginning of civil rights. Now the philosopher propounded the concept of natural right during the Renaissance period and the French Revolution. Okay, there they said there is nothing called divine theory of kingship, and each and every individual is entitled to certain inalienable rights, and they are called natural rights. As you can see, natural rights are those that are not dependent on laws, custom of any particular culture or government, and so are universal, fundamental, and inalienable. They cannot be repealed by human laws, though one can forfeit their enjoyment through one's actions, such as by violating someone else's right. So if I'm going to kill someone, then somebody can punish me and kill me too. But if I am not doing anything, nobody can kill me. That is my fundamental right to life. So those were natural rights. They were first recognized during the period of, you can say, American Revolution and French Revolution. And then came legal right. The main purpose of legal rights are to discipline the society, okay, so that the society should function in a proper way. Legal rights are those bestowed onto a person by a given legal system. They can be modified, they can be repealed, and restrained by human laws. The concept of positive law is related to the concept of legal rights. Then during the Age of Enlightenment, the concept of natural law was used to challenge the divine right of kings and became an alternative justification for the establishment of social contract, positive law, and government, and thus legal rights. The idea of human right is also derived from natural right. We are going to discuss part 3 of the Constitution. So in our Constitution there are several parts. Part 3 of the Constitution deals with fundamental rights, and that is the topic of today. So it starts from Article 12 to Article 35. Before we start, it is important to note that Part 3 of the Constitution provides for justiciable fundamental rights. That is, if those rights are not given to you, you can go to the court and demand them. Okay, these fundamental rights are protected against the invasion of the executive, legislature, or judiciary. And why at all this provision is there, that is fundamental right is there, to safeguard the citizen from the tyranny of the executive. Because if more power will go to the executive, they will try to exercise those power in a way which can take some of the rights of the citizen. So that should not happen. There should be certain common denominator which should be provided to each and every individual, certain rights which should be provided to each and every individual, and these are protected by the Constitution. The fundamental rights are negative rights because it puts some constraint on the state, the executive, legislature and judiciary, so they cannot do certain things. Okay, that is why it is called negative right. Not all but some. They are inspired from the Bill of Rights of the USA. This is very important, a question might come. They are inspired from the Bill of Rights of USA. The right to property, it was a fundamental right but was repealed. The right to property was deleted from the list of fundamental rights by which amendment? 44th Amendment, which came in 78 or 1978. And why it was done at all? And here we need to distribute the resources to bring equity. Okay, that is why it was done. It is made a legal right under Article 300A of Part 12 of the Constitution. Nevertheless, it is not a fundamental right, but it is a legal and constitutional right. Okay, because it is there in the Constitution, so it is a constitutional right as well. The fundamental rights are not absolute but qualified. So there are certain reasonable restrictions, okay, on all the fundamental rights except Article 17, which is basically an absolute right. They are available against the arbitrary action of the state or the tyranny of the state or executive. Article 12 defines the state for Part 3, which includes the government and the Parliament of India, the government and the legislature of each state, and all local or other authorities within the territory of India or under the control of Government of India. Okay. Article 13 defines what? Law. Article 12 defines state and Article 13 defines law. So all the law of pre-independence era which are inconsistent with this particular part will be void. Void means they will not be valid. Okay, the state shall not make laws against the provision of fundamental rights. Law includes any ordinance, so ordinance is part of law. Then order, rule, regulations, notification having in the territory of India the force of law. See, the fourth clause is important. Nothing in this article shall apply to any amendment of this constitution made under Article 368. So Article 368 deals with constitutional amendments. So if any amendment is made, then that will not be regarded as laws. Okay, so this is very important. Now we have divided fundamental rights into these many groups. They are right to equality, right to freedom, right against exploitation, right to freedom of religion, cultural and educational right, right to constitutional remedies. Now under right to equality, the first article is Article 14. It says the state shall not deny any person. So person means the citizens as well as foreigners. Equality before law or equal protection of laws within the territory of India. So the concept of rule of law also emanates from Article 14. Now Article 15 talks about the state shall not discriminate against any citizen on the ground only of religion, race, caste, sex, place of birth. That is 5 things: religion, race, caste, sex and place of birth, or any one of them. So here only is very important. You have only. So discrimination will not be made on only these grounds. Okay. On other grounds they can be made. Okay. Now come to Article 16. It talks about employment. Okay, under state offices. So there shall not be discrimination only on the ground of religion, race, caste, sex, place of birth, and 2 extra things are added: decent and residence. Okay, in case of public employment or state employment. Okay, then Article 17 talks about banning untouchability. It states untouchability is abolished and its practice in any form is forbidden. The enforcement of any disability arising out of untouchability shall be an offense punishable in accordance with the law. Okay, and it is only absolute right, you can say. It is absolute. There is no reasonable restriction here. Some restrictions are there for Article 14, 15 and 16, but here we don't have. Now come to Article 18. It talks about no title not being a military or academic distinction will be conferred by the state. That is, you can have military titles and academic titles. Apart from that, the state cannot confer any title to any citizen. No citizen of India shall accept any title from any foreign state. Okay, so this should be in. So basically, this Bharat Ratna and Padma awards, they are award, they are not title, and they should not be used as title. You can't say Padma Shri Kangana Rana. So the Bharat Ratna and Padma award are not titles and cannot be used as prefix or suffix to names, and they can be withdrawn by the government in case of misuse. So all the awards our Prime Minister gets, they are not title, they are awards. That is why they are allowed. Now Sachin was going to get this title of Sir, but according to Article 19, no citizen can get this title of Sir. That is why he was not given the title. Okay. Now come to this right to freedom. Before discussing right to freedom, we should understand it is very important. The right to freedom is very important because it creates a space for dissent. If I am not agreeing with whatever the government is doing, then I have this right. I can express myself. I can express my dissent. And how I can do that? Through right of freedom. So dissent is the safety valve of democracy. If you don't allow dissent, then the pressure valve of democracy will burst. So it is always good to allow dissent in a democracy. Then we have no chance of revolution. But if we will go on suppressing dissent, then that can burst altogether, creating grounds for revolution. Okay. Now fundamental right of freedom is, it starts from Article 19, 20, 21, 21A and 22. Now what is Article 19? It talks about 6 fundamental rights. All citizens shall have the right to, number 1, to freedom of speech and expression. This is very important because other rights like right to press and RTI also emanates from this particular right. We have the fundamental right to freedom of speech and expression. Be safe to assemble peacefully and without arms. That is why we see a lot of people, assembling in the farm protest, and before that also we have seen groups of farmers or groups of individuals, they assemble and protest together at Jantar Mantar, etc. That is allowed in a democracy. That is not allowed in China. That is not allowed in North Korea. But that is allowed. That is the beauty of India. To assemble peacefully and without arms. If you are doing that peacefully without arms, you are allowed. To form associations or unions. This is important for those of you who are appearing for HRM, because you have labor relations. In that, it will be a part of that. To move freely throughout the territory of India. You can move freely throughout the territory of India. This is one of the fundamental rights. If you are a citizen of India, because this particular right is given to only citizens, not to people. Okay, to reside and settle in any part of territory of India, and to practice any profession or to carry on any occupation, trade or businesses. Okay, then there are certain reasonable restrictions in there. Number 1, you cannot enjoy this particular right if you are doing something which is not in interest of sovereignty and integrity of India. Then if it is affecting the security of the state, if it is affecting the friendly relations with foreign state, if it is disturbing the public order, decency or morality, and in relation to contempt of court, you are not allowed to speak anything. For example, Kunal Kamra, he was charged under contempt of court. Okay, you can't just do anything. Then defamation or incitement to an offense. You can't defame a person and say that I have the right to speak whatever I want. No, you can't do that. And you cannot incite people for riots. That is also not allowed. So in India, freedom of press is implied from the freedom of speech and expression guaranteed under Article 19A of the Constitution of India. RTI or Right to Information Act is a fundamental right and is an aspect of Article 19(1)A of the Constitution. This is also very important. Okay, RTI is a part of Article 19(1)A, and there was a question in TISS that freedom of press is a part of which of the following right, and the options were Article 19(1)A, Article 19(1)C, Article 19(1)B, like this. So you should understand that it is Article 19(1)A. Okay, and Aruna Roy and Anjali Bhardwaj, they are RTI activists and are popular, so you should be knowing them. Now come to Article 20. It talks about no post facto laws, no double jeopardy, and no self-incrimination. No post facto law means suppose a person has committed a crime and now he has been sentenced. So he will be given that sentence, that punishment, which was valid when he committed the crime. Okay, suppose when he committed the crime, the sentence was of 5 years, but now the sentence is 8 years. So suppose he got arrested now after 10 years, so the punishment which he will get will be accordance with the punishment which was there before 10 years, not the current punishment. Okay, this is no post facto law. No double jeopardy, that is, the person will not be punished for the same offense twice by different courts. Okay, if I committed a crime, I will be punished once by a court, then again I cannot be charge sheeted and punished for the same offense. Okay, and it does not mean that if I robbed a bank, for example SBI today, okay, I got the punishment for that, and after 10 years I am robbing another bank, I will not get punishment for that. No, it does not mean that. It just means that I cannot get punishment again and again for the same crime I have committed. Okay, here for the same crime is single event, not double event. Okay, now no self-incrimination. No person accused of any offense shall be compelled to be a witness against himself. You can't compel a person to be witness against himself. So from here, right to silence, nobody can force me to speak up against ourselves. Okay, so the right to silence comes through Article 20 part 3 and also Article 19 part 1. Okay, now come to Article 21. It is important. It is basically protection of life and personal liberty. No person shall be deprived of his life or personal liberty except according to the procedure established by law. So some of the judgments which were passed recently were, you can say, related to Article 21. For example, right to privacy. The right to privacy is a fundamental right under Article 21. It is also known by Puttaswamy judgment. So there might be a case that they will give you this Puttaswamy judgment and will ask you, this Puttaswamy judgment is related to which of the following article or which of the following rights. Then it is related to right to privacy, which is under Article 21. Then Hadia judgment. It is also related to Article 21. It is also under Article 21. Right to marry a person of one's choice. So if the question comes, right to marry a person of one's choice is a fundamental right under which article, the answer will be Article 21. Then right to die with dignity. The Supreme Court held that the right to die with dignity is an intrinsic facet of right to life under Article 21 of the Constitution of India. It allows passive euthanasia, okay, and living will. So there was a case, the case was very famous. There was a nurse, Aruna Ramchandra Shangbhog, was an Indian nurse who was at the center of attention in a court case on euthanasia after spending nearly 42 years in a vegetative state. So she was raped. After that, she went into coma. She remained in vegetative state for 42 long years, and she was in pain each and every day. And eventually she died after 42 years. So the thing was, many activists, they fought a case to allow euthanasia so that she can die peacefully. But the Supreme Court, they didn't agree with active euthanasia, although they agreed with passive euthanasia and living will. So what is living will of a person? So basically it is a document where the person says that if he goes under certain conditions, you can commit passive euthanasia. Passive euthanasia is withdrawal of medicine or life support so that the person can, die peacefully. And then come to Article 21A. The Constitution 86th Amendment Act 2002 inserted Article 21A. Here it is important, 2002. The Right to Education Act that came in 2009 inserted Article 21A in the Constitution of India to provide free and compulsory education of all children in the age bracket of 6 to 14 years. And it is a fundamental right. And some of the initiative taken by the government was first the Right to Education Act, which came in 2009. The second was Sarv Shiksha Abhiyan. The third was Mid-Day Meal, Beti Bachao, Beti Padhao, etc. Then come to Article 22. Now Article 22 deals with the right of person who is taken into custody. The first part says that he has the right to know the reason why he is in custody. The second part is he should be allowed a legal practitioner of his choice. The third part says every person who is arrested should be brought to a magistrate within 24 hours. And then we have no such person shall be detained in custody beyond the said period without the authority of the magistrate. Okay. Now Article 22 also has a subclause or clause which talks about preventive detention. Now what is it? It provides that nothing contained in these two clauses shall apply to any person who is arrested in preventive detention law. So there are certain special laws which are called preventive detention law, where the state is allowed to arrest or take person into custody who is a threat to national security or public order. Okay, who is going to give inciting speech and whose speech can cause a riot. In that case, you can arrest that person. And there are several preventive detention legislations like MISA, that is Maintenance of Internal Security Act, which was passed in 1971, and in 1975 a lot of our leaders were arrested by the Indira Gandhi government. It was repealed when the Janata government came into power in 1978. Okay. Similarly, we had the National Security Act 1980, which is in function till date. Then we had TADA Act. TADA Act came in 1985, was repealed in 1995, and Sanjay Dutt was convicted under this particular act. Then we had POTA Act, which came in 2002 and was repealed in the year 2004. Then a special legislation which has been passed is Unlawful Activity Prevention Act, that is UAPA Act. Okay. Now under UAPA Act, the state has this power to pronounce a particular citizen as terrorist. Okay, this is a special thing about this act. And Preventive Detention Act or provisions can be brought by both center and the states. Okay. Now Article 23 and 24 are related to exploitation. Okay, so they are basically right against exploitation. Article 23 says prohibition of traffic in human being and forced labor. Traffic in human being and begar and other similar forms of forced labor are prohibited, and any contravention of this provision shall be an offence punishable in accordance with law. Then we have Article 24, which is important for those of you who are applying for HRM. No child below the age of 14 years shall be employed to work in any factory or mine or engaged in any other hazardous employment. And there are three legislation which are important. So here it is talking about the age limit of 14 years. No child below the age limit of 14 years shall be employed. Okay, we have three legislation. The first one is Factories Act, the second one is Mines Act, the third one is Child Labor Prohibition and Regulation Act. The Factories Act came in 1948. The act prohibits the employment of children below the age of 14 years in any factory. The law also places rules on who, when and how long can pre-adults aged between 15 and 18 years be employed in any factory. Now there is also a Mines Act. The act prohibits the employment of children below 18 years of age in a mine. This is important. Here it is 18 and there it was 14. The Child Labor Prohibition Act 1986. Here also you have the age limit of 14 years. A child is defined as any person below the age of 14 years, and this particular act prohibits the employment of child in any employment including as a domestic help, except helping own family in non-hazardous occupation. So just keep in mind one thing, that for all of them the age limit is 14 years, but for Mines Act it is 18 years, below the age of 18 years. Now we are going to see from Article 25 to 28 first. So they are related to freedom of religion. So Article 25 talks about freedom of conscience and free profession, practice and propagation of religion, subject to public order, morality and health, and to other provision of this part. All persons are equally entitled to freedom of conscience and the right to freely profess, practice and propagate religion. Now one of the example of public order, you can see there is a sect called Anand Margis. So the Supreme Court said no Tandava in public for Anand Margis. So they perform Tandav dance taking the skulls of humans in their hand. So the SC said that is not allowed because that will disrupt public order. Okay, so this is one example. Now come to Article 26, freedom to manage religious affairs. So subject to public order, morality, health, every religious denomination or any section thereof shall have the right to establish and maintain institutions for religious and charitable purpose, to manage its own affairs in matters of religion, to own and acquire movable, immovable property, to administer such property in accordance with law. Then comes Article 27, freedom as to payment of taxes for promotion of any particular religion. No person shall be compelled. If you have the free will, you can give, but no person shall be compelled to pay any taxes, the proceeding of which are especially appropriated in payment of expenses for the promotion of maintenance of any particular religion or religious denomination. Then Article 28 talks about freedom as to attend. Then Article 28 talks about freedom as to attendance at religious instructions or religious worship in certain educational institution. So basically it says if there is a state-run institution, there will be no religious instructions in them. Okay. Then comes cultural and educational right. You have Article 29 and 30. These are for protecting the interest of minorities. Now, sections of citizens residing in India having distinct language, script or culture of its own shall have the right to conserve them. No citizen shall be denied admission into any educational institution maintained by the state on the ground only of religion, race, caste, language or any of them. Then Article 30 says right of minority to establish and administer educational institution. All minorities, whether based on religion or language, shall have the right to establish and administer educational institution of their choice. Two types of minorities in India are based on religion and language. Then comes Article 31, which was repealed by 44th Constitutional Amendment, which came in 1978, which we already talked about. It says originally the right of property was one of the fundamental rights and provided that no person shall be deprived of his property except by authority of the law. But later it was repealed and made a legal or constitutional right under Article 300A of the Constitution. Now come to Article 32, which is one of the most important article of the Constitution. It talks about right to constitutional remedies. So Dr. B.R. Ambedkar had once said, if I was to ask to name any particular article in this Constitution as the most important, an article without which this Constitution would be a nullity, I could not refer to any other article except this one, that is Article 32. It is the very soul of the Constitution and the very heart of it. Now what is Article 32? What it says? Right to constitutional remedies. Remedies for enforcement of right conferred by this part. The right to move Supreme Court by appropriate proceeding for the enforcement of rights conferred by this part is guaranteed. Okay, so whatever right is there in part 3 of the Constitution, that is fundamental right, if they are not implemented, you can go to the Supreme Court. So this is one right which provides safeguards to those particular rights. Okay, the Supreme Court shall have the power to issue directions, orders or writs, including writs in the nature of habeas corpus, mandamus, prohibition, quo warranto and certiorari, whichever may be appropriate for the enforcement of any of the rights conferred by this part. Okay, now what are these? So basically there are 5 writs: habeas corpus, mandamus, prohibition, quo warranto and certiorari. We are going to see them one by one. So first focus upon habeas corpus or habeas corpus. So habeas corpus means to have the body of, and it is one of the most effective remedies available to a person illegally detained. So suppose you are illegally detained. Now what you will do? You will take the help of this particular writ. You will ask the court to issue this writ. By this writ, the court commands the person or the authority who has detained or restrained another person to present such person before the court. The court requires the detaining person to provide the grounds on which the person has been detained, and if he fails to provide a valid ground, the person who has been detained will be released and set free by the court immediately. Remember this with an example. Saaf Hajal files habeas corpus writ against detention. So when the Article 370 was repealed in Kashmir, Shah Faisal was detained. So he wanted to use this habeas corpus, but later he withdrew this particular thing. Okay, so that is a different story, but you can use it in case of illegal, detention. Then mandamus. What is mandamus? In the writ of mandamus, the Supreme Court orders inferior courts to do an act or abstain from doing an act. Okay, suppose some court is not doing his act, so the Supreme Court will say, please do this or please don't do this. This order can also be given to an inferior tribunal, board, corporation or any other type of administrative authority. Then we have quo warranto. Quo warranto asks by what warrant, by what authority you are doing such thing. The writ of quo warranto is issued by the court against a private person. Suppose a private person, he took control of a police station and he is saying that I am the inspector here, when he assumes an office on which he has no right. So if a private person goes to a police station and he says I am the officer here, he has no right of doing that. So the court can issue quo warranto, which literally means by what authority, and it is an effective measure to prevent people from taking over public offices. so that people could not take public offices. Then you have prohibition. This writ is not used many a times, but sometimes it is used. When the Supreme Court can issue this writ to an inferior court or tribunal for stopping them from deciding case which is not in their jurisdiction. If the court or tribunal does not have jurisdiction and it still decides the case, it will be an invalid judgment, because for an act to be legal, it should have the sanction of law. So Calcutta High Court cannot take decisions for Cuttack High Court. Okay, that cannot happen because that particular thing is not in his jurisdiction. So if something like that is happening, the Supreme Court can prohibit that particular court. Okay. Now come to certiorari. Certiorari is a different type of writ when compared with other writ. This writ is corrective in nature, which means the purpose of this writ is to correct an error. Certiorari is a writ which is issued by a superior court to an inferior court. This can be issued when the superior court wants to decide a matter in case itself, or if there is an excess of jurisdiction by the inferior court. This writ can also be issued when there is a fundamental error in the procedure followed by the inferior court, or if there is a violation of the principle of natural justice. If the superior court finds out that there has been a violation of natural justice or a fundamental error on the procedure adopted, it can quash that order of the inferior court. So basically it says, suppose there is an inferior court, suppose there is High Court, and then you have Supreme Court. Now High Court did something in which there was violation of principle of natural justice or fundamental error was there, and Supreme Court take notice of that error. So they can ask, whatever judgment you gave is invalid. Now the case will be decided by us. Okay, this is certiorari. So this was all which was important from this perspective in fundamental rights. In our next lecture, we are going to see directive principle of state policies. Okay.